Welcome to Infringe at Your Own Risk.
Hello and welcome to Infringe at Your Own Risk with Randall Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Kevin Rosenquist, and today we're covering copyrights. Rand will walk us through what they cover, how to secure them, and some common mistakes that can get creators in trouble. Rand, welcome back.
Thanks. But, you didn't have to draw out the decades.
I didn't have to do the decade thing? Okay, hang on. Let me rephrase that.
No, it was a joke.
He's still very young, but he has decades of experience. How's that? Is that better?
Yeah, it's scary when you start looking at your kids and thinking, you're getting old. And it's like, wait a minute, I'm your parent.
Wait a minute. Yeah.
Right.
All right. So let's just start real basic here. What kind of work can be protected by a copyright?
Okay, so copyrights cover a lot of things you would think of and some things you wouldn't. The common one that people think of, literary works, right? So a book,
Sure.
Dramatic works, a play or a movie, a musical, photographs are protected in copyright. Two things that people don't think of as much as computer software is usually covered by copyright. They can also be covered by patent. But software is easier, a lot easier. And architectural drawings and other artistic works. Right, so paintings, I've done a lot of litigation in architectural copyrights. Somebody comes up with a really cool new house design and it starts selling very well. And lo and behold, 20 other builders decide they're going to build the same thing.
Mm-hmm.
So it's basically any form of expression that's not transitory can be protected by a copyright.
Are you seeing some of the complaints for copyright changing now with AI coming around?
Oh, it's been huge. So a lot of people are suing the AI engines because, they're pumping all of this information in so they can do these large language models.
Sure.
But they're copying other people's stuff as they're doing it. And I just saw a case the other day, I can't remember the name of it, but where they did a class certification for people whose works had been used by one of the AI engines. So, it's an interesting time to be an IP attorney.
I'll bet. Yeah. Yeah, things are just gonna keep getting wilder too as we keep moving forward with this. I'm sure of it. So, real quick, I know we've talked about this in previous episodes, but just in case someone's just coming to us right now for the Copyright 101, how is it different from patents and trademarks?
Okay, so first of all, the subject matter. Copyright protects expression. It doesn't protect facts or ideas, right? So if you just have a bunch of facts, you can't protect that by copyright law. If you have just some vague idea, that's not protected. So, you can have an idea about a book about a little boy who becomes a wizard and has a bunch of weird friends and lives in a castle somewhere, right? That's a general idea, right? I can go out and write that book today, right? But I can't go and copy J.K. Rowling's work.
Mm-hmm.
Right? So the idea is not protected, but her expression of them is protected. And when you think about it now, copyrights are just amazing. You look at how many billionaires that we have who far faster than you ever could create $1 billion before have become billionaires because of their copyrighted works. I mean, you get someone like a Taylor Swift, right? Who composes songs, they become popular. You have many, many musicians who are worth billions, if not hundreds of millions of dollars. Just because they created a song and then they get paid when that song's used because they have copyright. If there were no copyright, you could just take a Taylor Swift tape, manufacture 20,000 copies and go sell them. But the copyright stops that. So it's protecting the expression.
Mm-hmm.
The other big difference with copyrights is copyrights you have to copy to infringe. Okay. So if I come up with something completely separate from you, if we wrote a story that sounded very similar, but I had never seen your story, I couldn't be a copyright infringer because have to have copied. Now, it's often hard to show that somebody actually copied. So the courts have a test where they say, okay, element number one, are they substantially similar? Yes, they're really similar. Okay. Number two, was there access? Right. So if mine is really similar to yours, but you had yours, you'd written it out, but you showed it to 3 friends, and then the copy was kept in your desk drawer for 10 years. That's going to be hard to find copyright infringement. But if you had put it on the internet and had 50,000 downloads of your story, and then I come up with mine that's very similar to yours, a judge or a jury is probably going to conclude that there's infringement. They're going to say, look, it's out there enough, it's reasonable that you accessed it and done that. So that's the 2-step that they go through. But sometimes you get actual evidence of copying. I think I told you previously about a client who he would do custom advertisements for people. And the alleged infringer said, oh, no, we didn't copy. We came up with that totally on our own. Well, the problem was he had written his copyright notice into his design. So when they copied his design, his copyright notice was in their design.
That's brilliant.
Well, if you came up with it all on your own, why did you put my client's copyright notice in your design? And then they called back very quickly and said, we'd like. So, but yeah, so copyright, the biggest thing in copyright is there has to be copying. Independent creation, it doesn't matter.
And to your point, when you brought up the wizard living in a castle with his crazy friends and all that, I mean, you could make a loose one on that, but if you have it very similar and you're calling the character Larry Cotter, you're probably like, and Harry Potter, it's obviously like everywhere, so it's not hard to find. So you're probably going to lose that case. Whereas if it was like more of an obscure book that maybe nobody really knows about, it would be different. Is that correct?
Absolutely. Yeah. You're going to have a much easier time convincing a jury this was copied if it's a very well-known work. Because the motivation's there, right?
Mm-hmm.
You're trying to trade off the popularity of the one book on yours. So, so it's much easier in front of a jury. Now copyright law is really interesting because it can be very draconian if you're an infringer. You get the option of proving damages, right? So if you copied my work, I can go and sue you and I can get your profits out of it and I can get my damages. So even if it didn't hurt me, if if I did a book and you used part of it and you used it for some other purpose, but you made a bunch of money, even though it didn't directly compete with what I'm doing, I can get your profits as my damages. Or if I can show lost sales, I can get my damages. Lost sales are often hard to prove. It's hard to prove that somebody didn't buy my product because of your product, right? That's often hard to prove. So the other thing, though, that copyrights can do is if you register your work, you can get attorney's fees, which in any case is huge because attorneys are expensive and cases cost a lot of money. So if the other side is having to pay your attorney's fees, that's a good thing. The other thing you can get is statutory damages. And statutory damages can range on a normal copyright. It can range from $750 to $30,000 for the infringement. And if it's willful, it can go to $150,000. So that's a big cudgel. And so a lot of people will, cave quickly because you don't want the risk of the huge award. Often the awards aren't that big, but they can be big. And having those attorneys' fees makes a huge difference in the litigation. Because if I'm going to spend $100,000 in a legal fight with you, I want a pretty good idea I'm not paying your $100,000 too.
Mm-hmm.
So the other important thing to understand it's really important to understand is how the registration date works. If you create something, you have 3 months to file your registration. If you do it in that window, you can get the statutory damages and the attorney's fees. Okay, so even if I release it today, right, I have until 3 months from today to file that registration, and I get those benefits regardless of when you infringed, either before or after I file the registration. Once that 3 months has passed, I have to have filed for registration before you started to infringe to get that. So sometimes we'll get someone who calls up and threatens a client who copied something and say, well, I want statutory damages and attorney's fees. And you say, well, that's nice, but you don't get them because your work wasn't registered when my client started infringing. So I would encourage people, if you're a content creator, whatever, if you have things that you think might be copied, file your registration. It's not that hard. You can go to copyright.gov, fill out the form. I mean, I do them for some clients. I prefer not to do them because for the time it takes me to do it, they like to say, well, you just filled out a form. It's like, yeah, it's extracting the information. But if I can train a client to go in and do their own, then they're much more likely to do them because the cost is pretty minimal. And then if somebody does infringe, you have those very strong laws that usually result in a much faster settlement.
So is the registration required to enforce your rights?
Yes, that's the other important thing. So copyright attaches as soon as you create something.
Sure.
But you have to register that copyright before you can file suit. And for years, there was a split. In fact, about 15 years ago, I wrote an article on it. Some courts said, well, you just have to have filed. The other said, no, you have to have the registration back in your hand before you can file the lawsuit. Fortunately, the Copyright Office has sped up quite a bit in the last few years. But the problem is this, somebody's infringing your work, right? You want to put a stop to it. If you don't have your registration, you have to then go to the Copyright Office, file for it, and it can take months. I mean, I've had ones that have taken well over a year to your registration. Well, in the meantime, somebody's infringing your work, and you can't do anything to stop them. If you registered it before, you have that benefit. There's also a way of expediting your registration, but it runs you basically about $1,000 more. So if you got something you think's going to be infringed, something you just kind of know when something's a hit, get your registration filed. So if somebody does copy, you're ready to go in and stop them right away.
I've heard people say things like, because as a podcaster, I've heard people say things like, oh well, as long as you're out there in the world, and then you're good because you can see the date, it's time stamped, all that kind of stuff. Is there any truth to that, or without that registration, is it not? It's not protected.
Well, you have, like I said, you have copyrights on your work, but you don't have the registration. So you're A, you can't file a lawsuit. And B, once you get your registration, you file the lawsuit, you can't get statutory damages or attorney's fees as long as it's been more than the 3 months.
Right. Okay.
If you've gone beyond that window, if you've done something and somebody infringes in 3 months, get your copyright registration file ASAP so you fall in that protective window, and then you can go back and get statutory damages and attorney's fees. And they really change the landscape of the lawsuit very quickly. I commonly, when I do a lot of my architectural cases, I'll get a call from the opposing attorney who's defending the infringer, and the first question out of their mouth is, "Was it registered?" And if I say, "Yeah," okay, we'll settle. They just don't want to put up a fight. They don't want to be paying 2 sets of attorneys to go through the process and then pay damages on top of that.
Right. Yeah.
So,
So obviously that was a misunderstanding of mine that I've heard from people. What are some of the other misunderstandings that you've come across when relates to fair use?
Okay, so fair use is can be way overused. The best analysis, quick analysis is, are you using it commercially? If you're using it commercially, you're going to have a really hard time arguing fair use.
Mm-hmm.
Because you're making money off of it. If you're using it educationally, yes. I mean, if somebody wanted to take a clip of this video and use it in a college classroom to explain something, right? They would be able to do that and most likely get a finding of fair use because it's used for educational purposes. Okay. If the same professor took clips of this video and started selling them to people, he's most likely going to lose a fair use analysis, right? So the court looks at how much of the work was taken. Is it being used commercially, or is it being used for an educational or for a comment? And so you see all the time people stitching videos together on YouTube and other social media content. That's usually considered fair use because they're doing it for comment purposes, right? They're just not saying, oh, look, here's this great video, watch it. They're showing part of it, and then they're analyzing, they're critiquing, they're complaining about someone's position, or they're supporting someone's position. That type of thing is much more likely to be found to be fair use than somebody who's just trying to profit off of it. So
Interesting. Okay. And with music, I've heard like the people say that oh, you can use up to 5 seconds of a song and blah 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 and all that. Is there any truth to that?
ask Vanilla Ice. Right. Bum 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 bum. Yeah. No, it's and it's really complex in the music field because there's a limited number of notes and whatnot, and there have been an amazing number of lawsuits going. 5 seconds doesn't necessarily shield you. Less likely you're going to be found infringing, but if it's clearly from the other song, you have a decent chance of getting tagged on it. And there's every time not every time, but a lot of the times when a star puts out an album and there's some hit songs, somebody comes out of the woodwork and says, that sounds just like mine. And some of them you listen and say,
yep,
wow, that's really similar. Yeah, I get it. I get it. And then other times you'll hear somebody and you'll listen to the two songs like, how on earth would anyone think that those two are related?
I totally agree. I've seen some of those as well. Yeah, where you're just like, I don't see it. I don't see it.
Yeah. I think it was Ed Sheeran who was in a suit. Somebody had sued him, and he actually sat down and paid like 10 popular songs, right? And how they all had these common elements in them.
Yeah.
And I think won the lawsuit because the jury said, yeah, that makes sense. And there's, we need a reasonable idea of where that boundary is. I think the courts need to do a little better job of identifying for musicians, here's what's okay. Yes, you can use certain riffs, right? Because they're commonplace. I think it was Dan Fogerty who actually got sued for infringing his own song. So he wrote a song. It was owned by a record label, and then like 5 years later wrote another song. And they sued him, claiming that his second song infringed his first song. So, and it could be awkward because if you're an artist, right, you tend to revisit themes that you're comfortable with.
Yeah. And you have if you're especially as a musician, you have a style, right? You have a certain way you play.
Yeah, you may not realize that you're infringing yourself. If somebody else
you're infringing on yourself. Stop infringing on yourself, dude.
Yes, exactly. Stop sounding like you.
Yeah, come on, man. Oh, that's funny. All right. Well, thanks for listening to today's episode of Infringe at Your Own Risk. Hopefully you got some information out of here that'll be useful. If you want to learn more or to connect with, or you want to connect with Rand, visit batemanip.com. Don't forget to subscribe to our channel, leave us a review. And remember, you can't use any of this without our express written consent. Right, Rand?
Absolutely.
All right. Well, thanks for being here. And thank you, Rand. Good to see you again.
Take care.
Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.